Hello friends, this is Manpreet. I am an assistant professor in Department of Laws, Punjab University, Chandigarh. I am here to make a presentation on fundamental duties incorporated under the Indian Constitution. In this presentation, I will be covering the following topics. Firstly, the concepts of rights and duties. Secondly, the concept, need and importance of fundamental duties. Thirdly, legislative measures for the enforceability of fundamental duties, including judicial pronouncements. And lastly, drawbacks in fundamental duties together with some suggestions. I will start with the introduction part now. The Indian society and the epics emphasize on the performance of one's duties towards others, the society, the country, and especially towards one's parents, without caring for the rights or fruits. Mahatma Gandhi rightly said that the true source of right is duty. If we all discharge our duties, rights will not be far to seek. Rights accrue automatically to him who performs his duties. In fact, right to perform one's duties is the only right worth living for and dying for. It covers all legitimate rights. The law confers rights and duties on every person as a unit of society. Right is an interest recognized and protected by a rule of justice, whereas duty is an obligatory act. Rights and duties are correlative, and therefore no right can exist without a correlative duty. The Constitution of India guarantees fundamental rights for the people of India under Part 3 of the Constitution. The framers followed the American model in adopting and incorporating these fundamental rights in the Constitution. These are certain basic, natural and inalienable rights. They have been declared fundamental because they preserve human liberty, they develop human personality, and thus preserve and improve social and democratic fabric of our country. Part 4, consisting of articles 36 to 51, are titled Directive Principles of State Policy. They contain the directives and duties for the state which we have borrowed from the Constitution of Ireland. They aim at setting up in India a social welfare state to ensure the common good and to secure to all its citizens socio-economic justice. But the framers of the Constitution did not declare any fundamental duties of the citizens. However, Part 4A, comprising of Article 51A, contains the fundamental duties of the citizens of India. This particular part was added in the Constitution by 42nd Amendment in the year 1976. These duties have been added to implement the recommendations of Swaran Singh Committee reported in the year 1976. It is worth to note that the constitutions of socialist countries lay great emphasis on these duties of citizens. It is very important to understand why these duties were not enacted in the Constitution as originally framed. There are certain reasons behind this. The framers of the Constitution did not feel the need to enact these fundamental duties in the Constitution for the following reasons. Firstly, the framers of the Indian Constitution were noble persons and freedom fighters. To them, Indians were duty oriented people. These basic values were inherent and practiced by each and every one and were nurtured in the home, schools and colleges. These were integral part of the way of life in India, and therefore no need was felt to incorporate these duties specifically in the Constitution. Secondly, it is the duty of the citizens to achieve the ideals and aspirations enshrined in the preamble to the Constitution. Thirdly, all the rights enshrined in Part 3, that is fundamental rights, have inbuilt obligations therein. Right in A means duty in B. Existence of a right implies existence of a duty. That is why we say that rights and duties are correlative. However, with the passage of time, values in society and public life started degrading, and the nation felt the need to incorporate these values specifically in the Constitution. There are 11 fundamental duties under Article 51A. I will start with the first one. to abide by the Constitution and respect its ideals and institutions, the national flag and national anthem. Secondly, to cherish and follow the noble ideals which inspired our national struggle for freedom. Thirdly, to uphold and protect the sovereignty, unity and integrity of India. Fourthly, to defend the country and render national service when called upon to do so. To promote harmony and the spirit of common brotherhood amongst all the people of India, transcending religious, linguistic and religion or sectional diversities. To renounce practices derogatory to the dignity of women. Next, to value and preserve the rich heritage of our composite culture. To protect and improve the natural environment including forests, lakes, rivers and wildlife, and to have compassion for living creatures. Next, to develop the scientific temper, humanism and the spirit of inquiry and reform. To safeguard public property and to abjure violence. To strive towards excellence in all spheres of individual and collective activity, so that the nation constantly rises to higher levels of endeavour and achievement. Lastly, a duty has been put on the parents or guardians to provide opportunities for education to his or her child, as the case may be, ward between the age of 6 and 14 years. It is very important to understand the importance of fundamental duties. They have great moral force and comprise code of conduct for the citizens of India. They play a vital role in the success of democracy through active participation of people in the process of governance. They are intended to create psychological consciousness among the citizens. They are intended to serve as a constant reminder to every citizen to observe certain basic norms of conduct towards the nation, thereby establishing and strengthening the democratic structure. They help in interpreting other provisions of the Constitution also. They form the basic structure of the Constitution. Talking about the enforceability of fundamental duties, there is no legal sanction for violation or non-performance of fundamental duties. They have an inherent element of compulsion regarding compliance. Out of the 11 clauses in Article 51A, some are positive duties while others are negative duties. Now, we will discuss the legislative measures for the enforcement of fundamental duties. Various laws have been enacted for the enforcement of fundamental duties. In order to ensure that no disrespect is shown to the national flag, the Constitution of India and the national anthem, various laws have been enacted. For example, we have the Prevention of Insult to National Honours Act of 1971. We also have the Emblems and Names Prevention of Improper Use Act of 1950, which was enacted to prevent improper use of the national flag, the national anthem and the flag code of India. Similarly, we have our criminal laws. They ensure that the activities which encourage enmity between different groups of people on various grounds, these are adequately punished. For example, section 153A of Indian Penal Code prohibits activities aimed at creating a feeling of insecurity or ill will among the members of other communities. Likewise, imputations and assertions prejudicial to the national integration constitute a punishable offence under section 153B of the IPC. A communal organization can be declared unlawful association under the provisions of Unlawful Activities Prevention Act of 1967. Likewise, offences relating to religion are also covered in sections 295 to 298 of the Indian Penal Code. Other legal provisions for the enforcement of fundamental duties include provisions for the protection of civil rights Act 1955. This was earlier called the Untouchability Offences Act of 1955. Sections 123 subsection 3 and section 123 subsection 3A of the Representation of the People's Act 1951 declared that soliciting of vote on the ground of religion and the promotion or attempt to promote feelings of enmity or hatred between different classes of citizens of India on the grounds of religion, race, caste, community or language is a corrupt practice. A person indulging in a corrupt practice can be disqualified for being a member of parliament or a state legislature under section 8A of the Representation of People Act of 1951. Then there is another law, Prevention of Cruelty to Animals Act 1960. Now, we have another law which has been passed recently. This is Right of Children to Free and Compulsory Education Act 2009. This has been made to give effect to the fundamental duty which is contained in the last clause of Article 51A. Then There are pollution laws like Water Prevention and Control of Pollution Act of 1974, Air Prevention and Control of Pollution Act of 1981, the Environment Protection Act 1986. It must be noted that in pursuant to various judgments of the Honorable Supreme Court relating to environmental issues and having regard to the complex issues of facts of science and technology which arise in environmental litigation, and in particular in the elimination of pollution in air and water, in September 2003, the Law Commission of India in its 186th report made a proposal to constitute multifaceted environmental court with judicial and technical or scientific inputs. It is very important to understand the drawbacks in fundamental duties. For example, these duties are non-justiciable. Certain fundamental duties are so vague in their meaning and are not so worded so as to enable a common man to understand the underlying meaning of these words. It is also not clear that what action would be taken in case of violation of fundamental duties. Very less percentage of citizens of India know about the existence of this article in the Constitution. Now I'll be discussing the role of judiciary, which is very important because the courts in India have given various interpretations to these fundamental duties. The apex judiciary in India in a number of cases has given harmonious interpretations of Part 3, Part 4 and Part 4A of the Constitution, thus signifying the importance of fundamental duties. For example, in Chandra Bhavan Boarding and Lodging versus State of Mysore 1970 Supreme Court, it was held that it is a fallacy to think that in our constitution there are only rights and no duties. Part 3 is to be read along with Part 4 and 4A of the Constitution. This was the harmonious interpretation of Part 3, Part 4 and Part 4A. Similarly, in AIMS Student Union versus AIMS, again decided by the Supreme Court in 2001, it was held that these duties are fundamental, basic and provide a valuable guide and aid to the interpretation of constitutional and legal issues. In rural litigation, Entitlement Kendra versus State of UP, again decided by Supreme Court in 1987, the Honorable Supreme Court issued directions to the state having regard to Article 51A G, preservation of the environment and keeping of ecological balance unaffected is a task which not only governments but also every citizen must undertake. It is therefore a social obligation. Similarly, in Shri Sachidanand Pandey versus State of West Bengal, again decided by Supreme Court in the year 1987, the court held that when any court is called upon to give effect to fundamental duties, it is not to shrug its shoulders and say that priorities are a matter of policy, and so it is a matter for the policy making authority to draft a policy. Similarly, in MC Mehta versus Union of India 1988 Supreme Court, the Supreme Court, in order to implement the duty as to improvement of environment, has given a number of directions to the central government. Similarly, another case was decided by Andhra Pradesh High Court in Chandra Rajkumari versus Police Commissioner Hyderabad. The Honorable Court observed that holding of beauty contests by depicting in any manner the figure of a woman so as to have the effect of being indecent or derogatory to the denigrating to women offended Article 14, 21 and 51A(e). Another very important case decided by Supreme Court was Bijoy Emmanuel versus State of Kerala in the year 1987. The Supreme Court in this case held that not joining in the singing of national anthem did not amount to committing its disrespect. Likewise, in S.N. Choksi versus Union of India 2003, this case was decided by the Madhya Pradesh High Court. It held that putting ban on the exhibition of film Kabhi Khushi Kabhi Gum, the Madhya Pradesh High Court issued appropriate directions against the dramatization of the national anthem in films. Likewise, in Union of India versus Naveen Jindal, this case was decided by the Supreme Court in 2004. The apex court suggested making a law, making an enactment for the matter concerning national flag of India. Now, there is another judgment which is decided by the Supreme Court. It was the case of State of Uttar Pradesh versus Jamuna Shankar Mishra versus another. It is an interesting case where the object of writing the confidential reports, which we generally call ACRs, and making entries in the character rules were read in the light of Article 51 Clause J as giving an opportunity to a public servant to improve excellence, thus improving and strengthening public services. The Supreme Court again in a very landmark judgment, this is Vishakha and others versus State of Rajasthan, in the year 1997, the Supreme Court issued certain guidelines to ensure the prevention of sexual harassment of women at workplace. Recently, on 12th of April 2012, the Honorable Supreme Court in Society for Unaided Private Schools of Rajasthan versus Union of India and another held that unlike other fundamental rights, the right to education, which is given under Article 21A, places a burden not only on the state under Article 45, that is directive principle of state policy, but also on every parent or guardian to send his or her child to school or to educational institution for the purpose of education. This particular duty has been enshrined under Article 51A Clause K. Then we are going to discuss the recommendations of National Commission on the Review of Constitution. These recommendations are extremely important because these recommendations provide for some additional, they have suggested certain additional fundamental duties to be incorporated in Article 51A. The Government of India appointed a committee in the year 1998 under the chairmanship of Justice J.S. Verma for the purpose of educating people about their fundamental duties. Now, until we educate the people about their duties, the purpose of incorporating these duties in the constitution will frustrate. The committee submitted its report in October 1999. The commission, that is National Commission on the Review of Constitution, examined this report and gave the following recommendations. It said that for giving effect to fundamental duties, the following steps should be taken. Number 1, to sensitize the people and to create a general awareness through the print and electronic media. Now, here the role of media is very important. Now, secondly, reforming the education system and policy, including teacher training programs. Thirdly, we should encourage and monitor the role of NGOs, that is non-governmental organizations. There is a great need to strengthen the role of various professional bodies like lawyers, like doctors, all these professional bodies, so that they can also contribute towards the awareness, towards creating awareness among the masses. The following, the NCRC, that is National Commission on the Review of the Constitution, also recommended that following duties should be incorporated in Article 51A. It is very important that these duties should be incorporated in the Article 51A. Firstly, that is to foster a spirit of family values and responsible parenthood in the matter of education, physical and moral well-being of children. Secondly, it also recommended a duty of industrial organizations to provide education to children of their employees. Thirdly, there is another duty recommended by the Commission, that is duty to vote at elections, then duty to pay taxes, and lastly duty to resist injustice. All these duties, though they have not been incorporated under Article 51A, but we all know that these are so important duties that these should be incorporated in the Constitution. Another important recommendation is to strengthen the role of courts. The courts here perform a very good function in interpreting various provisions of the Constitution, including fundamental duties. Though these duties are not enforceable, yet the court have given various judgments for the enforceability of these duties. Then the Supreme Court in India, Union of India versus R. Padmanabhan in the year 2003, the Supreme Court has directed the central government to take appropriate steps for the implementation of the recommendations of the Commission as expeditiously as possible. To conclude, a common thread runs through Part 3, 4 and 4A of the Constitution of India. In the Ramlila Maidan incident, the Supreme Court has held this. It will create an imbalance if undue or disproportionate emphasis is placed upon the right of a citizen without considering the significance of the duty. The true source of duty of the right is duty. Mahatma Gandhi also opined that the true source of right is duty. If we fulfill our duties well, right is no far to achieve. When the courts are called upon to examine the reasonableness of a legislative restriction on the exercise of a freedom, the fundamental duties enunciated under Article 50A, 51A are of relevant consideration. We all know that rights, though a Constitution of India has guaranteed various rights, various fundamental rights, but we all know that these rights are not absolute, they are subjected to certain reasonable restrictions. These duties are of constitutional significance and the foundations of human dignity and national character. There is a need to reconcile private interests with those of society as a whole, and to make the individual citizen to be conscious of his social and citizenship responsibilities irrespective of any considerations, and to shape the society that we all respect inalienable rights of our fellow citizens. Awareness of our citizenship duties is as important as awareness of our rights. Fundamental duties are not just a mere reminder. Thus, there is a need to enact suitable law, suitable legislation wherever necessary to require obedience of the duties by the citizens. To summarize the whole presentation, I would like to add that in this presentation we did not only discuss the rights and duties of that these rights and duties are coexistent. This means that where there is a duty, there is a right, and vice versa also. Where there is a right, there is a coexistent duty. No right can exist without a corresponding duty, but the fundamental duties are so basic and so important that we call them fundamental. This is the reason we call them fundamental. Then we also discussed the need and importance of these duties. Though these duties are not enforceable yet, like fundamental rights, because all the fundamental rights are enforceable in the court of law, yet these duties are not enforceable, but there is a public sanction behind them. Law does not protect these rights, the law does not protect these duties, but there is a public sanction, public opinion behind them. Then I also discussed the importance of these duties. I also discussed various laws that have been enacted for the enforceability of these duties. Then we discussed various judgments, the role of judiciary in interpreting and enforcing these fundamental duties. Various suggestions of the National Commission on the Review of Constitution have also been discussed. I strongly suggest that the duties suggested by the Commission should also be incorporated in our Constitution, but because these duties, though they are not categorized as fundamental duties, but they are so fundamental, so basic that every citizen must perform these duties, and the incorporation of these duties is strongly suggested. That is all. Thank you.